podcast, people. This is estate planning and asset protection attorney Leslie Marenco bringing you another episode of Having Fun with Death and Taxes. And today I am joined by my friend and colleague, George. Please introduce yourself.
Hi, I'm George Alvarez, and I do probate and estate work.
So today we're going to be discussing Tony Hsieh. Mr. Hsieh died at the end of 2020. He was 46 years old. He was not married. He did not have any children. So he was survived by his mom, his dad, and two brothers. The year before, the year during, I guess, that he passed away, as we were discussing, he abruptly kind of moved out of Nevada, where he was living, to Park City, Utah, which is just the last thing in kind of a spree of a little bit of erratic behavior that he had that year that we are going to talk about. But his estate was worth somewhere between, and depending on where you get the information, $700 million to over $1 billion. So he clearly invested that 1.2, I guess, well, or something, because even quite a few years later, 10 years later, he still had quite a bit of that money in his estate. So he didn't blow it all. He died of smoke inhalation at a house fire that initially seemed a little suspicious, and I didn't find anything else about that. So we won't be talking about that today. No Slayer statute or anything going on in this episode. As far as his estate plan, or lack thereof, initially there was just no estate plan. Nobody said they found anything. Dad and brother were appointed executors, and they said, we can't find anything. The attorneys that he has ever worked with for any reason, none of them had a will or anything like that. And so it seems like he would have died intestate, and mom and dad, just like in Florida and Nevada, would have inherited the entire estate. Although there's some articles definitely talking about how monumental a task it was going to be for dad and brother to even piece together this estate, because other than, I guess, the normal bank accounts and stuff, he had bought so much stuff in LLCs, not organized at all, so much real estate when he moved to Park City. He had invested in so many projects. It was just a mess. And I'm sure you see that with your real estate investors, right? Like, they open up LLCs, or their CPA opens up some LLC, and then they start accumulating LLCs, and little do they know, 16 LLCs later, they're like, did I just lose my shopping mall? What do you mean? You know, like, what's going on here? So,
and as we know, too, at 46, he didn't think that he was going to die.
Not at all.
So they don't do proper estate planning, especially when you don't have kids or anything like that. You don't think about these things, but anything can happen at any time.
Yeah.
And then there's the rest of us left to clean up this mess.
And what a mess it was, and it's turned into. Because even before last year, 2025, the estate was still going. Brother and dad were still trying to piece together what are the assets, what are the debts, who owes who money. There were articles about over 1,000 sticky notes in his house that look like business dealings, or, Fulanito owes me money. I promise Fulanito I don't know what. My best friend Chad gets a house. I own these other houses that my other friends are living in, because apparently when he moved to Park City, and it's funny, there's so many, Park City, there's been so many conferences in Park City lately, and I even have one coming up in June. Before last year, I wouldn't even know Park City, Utah was. But Park City's up and coming, I guess. And that's why he was investing in real estate projects there. But he moved all of his friends with him. He said, okay, guys, I know you all have great jobs elsewhere, but if you come live in my city so we can continue being BFFs, I'll pay you double, right? And that sounds crazy. Right? That already sounds a little erratic. That already sounds a little, all right. But hey, neither I don't know about you, George. I don't got $1 billion. Maybe if I had $1 billion, I'd move all my friends. And I always think that what we perceive as funny behavior, erratic behavior, kind of crazy things to do, would it really be all that crazy if we had that kind of money? Maybe not. Maybe not, right? So
as you know, like the brother and the father are left now as the personal representatives. And the job is to marshal the assets, as they like to call it. And now you have to start searching and looking everywhere to see what those assets are.
Yeah.
And how do you find that out from sticky notes? It's kind of hard.
1,000 sticky notes.
And people create companies in different states now and different things because in Florida, they should not benefit you. So you might go to Wyoming or Delaware. And it's, how do you find all those places?
Right.
People ask me all the time and they come to me and say, hey, how do I find out about these assets? And I said, well, hire a PI. I
Right.
do that. I can't find out because, they could be anywhere.
I get that a lot from particularly South Americans. They really believe there is like central database, right? Like, I guess because all of these laws and FATCA and this and whatever, and, and the United States not sharing information, but other countries sharing information with us and whatnot, has given the world, and I think particularly Latin Americans, this concept that, the U.S., of course, knows all my assets offshore if you're a U.S. person, they think. So they must know assets onshore, right? Clearly just go into that database, lawyer, that's what we're paying you for, and go find, my deceased husband's bank accounts and whatever. I once had a widow call us and she was like, no, it's in the money in the bank in Doral. And I was like, lady, there's like 300 banks in Doral. Have you lost your mind? I don't know who you're paying to go door to door with the court order, going, hey, are there any, accounts in the name of my husband? And that is the perception. They really do think it's going to be as easy as plugging in an ITIN number, or plugging in a social and getting all the accounts, getting all the stuff, No, it is not that easy, guys. You will be paying a private investigator to do a lot of legwork, actually. And even when they, and it's usually breadcrumb legwork, because they'll come up with, a few things on a credit report or something, and that just gives us a place to start requesting information. So this is a very expensive ordeal. This is what it becomes, a very expensive ordeal. At the beginning of last year, we have a will just appear out of the ether, out of nowhere. And the story behind this will is probably some of the craziest stuff I have ever heard. We do a lot of estates here. This podcast mirrors our newsletter that we've been writing for almost 10 years. And so we write a lot about a celebrity estate planning, or even wealthy entrepreneurs or moguls or whatever it is, and their estate planning. So last year, a will all of a sudden appears. And the story behind where this will has been all along is that it was in the possession of Mr. Pir Mohammed, who lived in Pakistan. And the reason why they didn't know about this is that Mr. Mohammed just passed away. And so when his relatives were going through his stuff for his estate, I guess, they found the will. And they said, of course, Tony would have given my relative, Mr. Mohammed, this will for safekeeping. And apparently Tony also mentioned, total hearsay, that he didn't want anyone else messing with the will. And the will makes reference to multiple other trusts and a California trust, all of which are actually delineated one by one in pleadings, which have really crazy names. But that's neither here nor there. You can name your trust whatever you want, I guess. It's that nobody can find any of these trusts anywhere. There's also references to videos that Tony wanted to make to explain why he made this will and those trusts and gave it to Mr. Mohammed. And so the relative of Mr. Mohammed, who's named Tony Hsieh, says that he really did find this in the possession of Mr. Mohammed, which is his grandfather, who was
In Pakistan.
With Tony. DFFs, dear friends, and I quote, very dear friends, with Tony. And now Mr. Mohammed was actually not going to be under this will, going to be inheriting much, if anything at all. But Mr. Kashif is going to be inheriting under this a significant amount of money. And so just to recap, guys, in the last 5 minutes, we have the will of an American billionaire who is somehow sitting in another country with some guy that nobody's ever heard of, right? When they go asking all of Tony's many, many, many friends, drug friends, party friends, whatever, we all have friends of different age stages of our life and what have you. So whether you talk to the friends in Nevada or the new friends, the party friends in Utah or whatever it is, none of them have ever heard of Mr. Muhammad. So this was like a secret.
Go figure.
Friendship. I mean, very hush.
So let's talk about this. So this will that was in Pakistan, there are certain formalities that need to be followed to see if that will is valid.
Oh, but the will was signed here.
It was signed.
It was signed in, allegedly signed in Nevada. And there were 4 witnesses because we're overachievers here, like there are 4 witnesses, not 2. And Nevada's just like Florida. You only need 2. So there are 4 witnesses and there's a date on the will and there's a signature. Now it was handwritten, but it does abide by all of the things that Nevada needs to make it a holographic will. It shows its intent, signed by 2 witnesses. It's signed by the testator. And for all intents and purposes, it would be, and it has been admitted as something that needs to be looked at.
And a will in Florida can have 2 witnesses, but it does not have to be notarized, but it helps.
Right. It definitely helps because you got to hunt down those witnesses.
Right. And so was it notarized?
It was not notarized.
Not notarized.
It was not notarized.
So those witnesses to that will in Nevada, where are they?
Oh, they're nowhere to be found. So they have, of course, from February, when this magical will appeared, you can imagine dad and brother. Well, first and foremost, that will has its own personal representatives, which are actually 2 lawyers in Nevada with their own law firms who must have thought, oh my God, it's Christmas in February. Like, I have been named personal representative in a will for the estate of Mr. Zappos here. You know what I mean? I now get to get my attorney's fees out of the estate. I am going to go benefit the estate by trying to see if we're going to, and they were not the ones that submitted the will. It's not that they were mailed the will in the 3rd attempt. So apparently the first attempt to mail the will directly to the court was rejected because it didn't have the $18 that it needed, right? So isn't that funny that like the clerks are the same everywhere? Like, what is this crap? No, I don't have the $18. I'm not filing shit. Then apparently someone made a call to the clerk, got better instructions, found out they needed a money order for $18, which has been tracked to like a Western Union or something in Pennsylvania. And then it was mailed. They tried saying that it was mailed from Nevada. That is a lie. That has been determined to be a lie. It was mailed out of a post office in Pennsylvania. The first time it was mailed out of a post office in Connecticut, which is where he died, which was interesting, right? And that time it had the $18 money order. So it was, it was accepted. And then they mailed it directly to the attorneys saying, hey, congratulations. Please do something about this. And they were like, oh my God, I can only imagine.
So they had nothing to do with the preparation of the will. They were just named.
They were just named. Who knows if they showed up at the top of Google? Who knows if ChatGPT, well, this was last year. Was there ChatGPT a year ago? Yes, right? Yes. ChatGPT said these will be great lawyers.
Happened to what?
I don't know.
It never happened.
This would be fantastic.
30 plus years as an attorney. Never happened.
Never. So just the way that this will was sent to the court and people actually found out about its existence was already kind of interesting. So it has these 4 witnesses. The 4 witnesses have addresses and all of this in the will. Substantial investigations have been done about these 4 witnesses. They cannot find the 4 witnesses. The addresses are either fake or a commercial address. Subpoenas have been sent to the housing complexes to see if anybody ever lived anywhere in that vicinity named whoever, because the names are just as wild as Kashif Singh. Like, I mean, there was certainly a group of friends here that we have that were witnessing
Because as you and I know, I don't know if the law is similar here in Florida. If you could find one witness, just to oath of one witness
Right.
to validate that will.
Yes.
And so, but they haven't been able to find any of the witnesses.
They haven't been able to find any of the witnesses. And there's even talk about how there were emails in the document. And when they initially emailed that email address, like even Mr. Muhammad had like an email. It was like PM, Pure Muhammad at PM Wealth, no sé qué, consulting and whatever.com, right? But of course, guys, it's, like I used to, my old boss used to say, it's really hard to commit fraud. Well, when you're going to do these shenanigans, you kind of need to think through your bullshit, because obviously it's really easy to subpoena, and it's not, I shouldn't say that. It's not easy to subpoena. It's actually quite a rigmarole to subpoena any one of these servers or any one of anything. If you're going to subpoena AOL.com or whatever, it's going to take a while, and you're going to have to get on the phone. You're going to have to get on the phone with counsel. And it's not just like, oh, things are going to magically appear. It's not that easy if they respond at all initially. But they were able to say that PM at PM Wealth, my Tony friend BFF.com, whatever it was, just, became in existence last year or whatever it is. The same thing with the other Gmails or wherever these witnesses, because all of their emails are listed. And initially somebody responded to these emails. They have no longer responded, right? As this has progressed, again, it's kind of hard to keep up the alleged fraud as you go through this, because more and more evidence gets stacked against you. Leading to, because they've done all of this due diligence, they have an expert, handwriting expert, saying that is not Tony's signature, that is a total forgery. They have, of course, 100 affidavits from all the friends saying, we have no idea who these people are. None of us have ever heard of these people. Tony never mentioned them. Not only that, they have like affidavits saying Tony would have never left money to Harvard, which actually was his alma mater. So it doesn't seem strange initially. I thought that there was a couple $1 million left to Harvard. I'm sure Harvard's attorneys have some skin in the game now. They're like, what do you mean? What do you need? Of course this will is valid. We would really love our $3 million. So they have quite a bit of evidence that by the pleadings at the end of last year, you saw, wow, a lot of work has been done by Holland and I out there to show that allegedly this is totally a fraud.
Well, they're doing a lot of due diligence because the stakes are so high.
Yeah.
The estate is so large. And the attorneys, obviously, not to say anything, are trying to justify their fees.
There's been $18 million as of last year.
Again, isn't
that amazing? I was like, that's great. That's fantastic.
But as we know, if it's similar to Florida, that without any of the witnesses being found and without having a notarized document, which would make it self-proving, that chances are that will is going to be thrown out.
Yes.
Chances are. If we had to bet on it, we would probably say it's going to be thrown out, not accepted.
Yeah. And here in Florida, if you can't come up with XYZ, it does not become an issue of, oh, go prove this by, some fact witnesses or whatever. The document fails here in Florida. I'm actually not so sure if that's Nevada law, just because in the pleading, you see them go through this, we believe the document fails, this is all bullshit. But then they start talking about the intent, and they start talking about the lack of factual evidence. They really pad, now that could just be for safekeeping, let's get this all on the record right now, right? Or it could be that maybe there is some way to get extrinsic evidence into the docket and see if we can prove this will up by some external evidence.
And I throw in just a little side fact.
Yeah.
On a side case that I had a case from California that had a will, and then it led money into her trust. And it was not self-proving. It only had 2 witnesses. We could not find the 2 witnesses. However, in California, interesting enough, I found out that the law over there does not provide for self-proving wills. It does not, a will to be valid does not have to be self-proving. And as long as it's signed by 2 witnesses, it's valid. And I was able to get the will admitted. The certain identifying information saying that they were identified at that moment, that was sufficient. It didn't have to be self-proving, and I didn't have to get an oath of witness in California for California will.
For California.
Yeah, and I was able to submit a memorandum of law here in Miami-Dade, and the judge admitted the will, and then money was able to be transferred to the trust.
That was actually going to be my next question. Did they accept your interpretation, or did they want some California attorney affidavit?
Well, they accepted my interpretation, and I submitted the Florida statutes and everything, and the provided and the California rules of procedure,
Right.
or procedure, and they accepted it.
Very good.
Worked out really good.
That's so
This interesting case. But
Yeah.
anyways, so we think that this will for Tony Hsieh is not going to be accepted.
We do not believe it's going to be accepted. It is a little out there in a lot of the facts here. Even like the names of these witnesses, I hate to say it like that, the names of these irrevocable trusts that supposedly this will refers to are just what, I mean, none of this even seems very like standard of what something would look like if anyone that knew what they were doing, any lawyer ever looked at this, any even notario or something, like doing the unlawful practice of law. This all seems very Nigerian prince scam to me. It really, allegedly. Don't come for me, people. I don't need like intellectual property defamation lawsuits here. But it is kind of like, wow. I mean, does anyone really believe that in an estate that's, I guess, an estate being this big is what makes it attractive enough to try to pull these shenanigans, right? But an estate like this is going to have so much publicity. I mean, this comes out of the woodwork and everybody's going to write about it. The way I found out about this a couple months ago was the New York Times wrote something about it. And it was called like the mystery $500 million at stake will. And I was like, what? What are you talking about? And I clicked it because it's on my radar to get anything. They're like, exactly. And so I'm like, really, guys? Wow, this is a little out there. It really, truly is. But who knows? Who knows how these things come about and how these things maybe start off as one thing and turn into something else. I really don't.
It was interesting, I think, in a conversation that you and I had about this was just, again, if you're going to do fraud, put in, and it was like, it's gifts to the Harvard endowment and do a couple charities and then the significant amount of money went to the private individual.
Yeah.
But do your fraud. If you're going to do your fraud, try to do it well.
Yeah. And they threw in this no contest, clause that here in Florida, we know not acceptable. Even though we see practitioners throw them in all the time. Sometimes it's psychological, right? We think, okay, we'll throw it in there. We know it's not valid, but maybe somebody else will look at it and be like, okay, let me not go starting frivolous litigation for litigation's sake. I might get cut out altogether. It looks like over there, it is not blatantly invalid. It only, the way, I mean, I actually really love Florida's rule. I think in a way, you want people to come forward with their grievances, with whatever they believe happened. If grandma was being taken advantage of, if grandma was unduly influenced, if grandma was on ketamine and psychedelics and therefore shouldn't have been signing, the will. You want all of these things to come forward without this idea that, oh my God, if I even bring this claim, I might cut myself out of whatever I am getting. Right. I like the public policy that Florida has. It looks like in Nevada, that is not the case. The clause can stand if it's seen to be frivolous or you didn't have a good reason to bring it, but in and of itself, it will be allowed. So you are able to claim against the other person's inheritance if they brought this claim against the estate, and then you don't win, or it's looked at, I believe the standard is much more than you didn't win. It's looked at as you brought this frivolously or you didn't have enough facts to really say it should be invalidated. So that is, again, more litigation in a way, because now you have to show, what evidence did you have to bring this to begin with? Again, more factual stuff that has to be proven.
And I think we talked about too that there was alternative pleadings also. So even if this will, by some crazy standard, gets admitted, they may challenge it because he was acting kind of nutty right before he passed away. Right?
Absolutely. There is a lot of talk about that in almost everything you read about this estate, because he was acting quite erratic. And I mean, back to what I said before, maybe we had $1 billion, it wouldn't be as erratic as we think. Because, I mean, I don't know about any of these psychedelics or where you get these mushrooms or whatever they are. I wasn't around in the 70s, guys. Now I hear you can like get a prescription for these things or whatever. Um, yeah, or whatever. Yes, exactly. I hear there's like doctors that'll prescribe you ketamine because you have anxiety or whatever. And I'm sure the more money you have, the more you have access to these doctors, etc. So, but yes, he was acting quite erratic, especially in the last year. They say COVID, because this is all during 2020. He dies at the end of 2020, that COVID exacerbated a lot of those mental health issues, made his substance abuse problems worse, and that he actually had been convinced, the Wall Street Journal says, again, don't come for me, that he was going to check himself into a rehab after the new year, except he died right after Thanksgiving. So he never got to check himself into a rehab. But certainly, I would imagine dad, even though, we think of undue influence or we think of a lack of capacity, and we immediately start thinking of grandma, right? Grandma's 90 years old. She's a little cuckoo for Cocoa Puffs now. She doesn't know where she is. She doesn't know what year it is, who's the president, whatever. And we start really questioning if there's too many changes, if things have drastically changed from one version of a will to another, if all of a sudden, what is the usual story? Like the caretaker is now inheriting the house, right? We got a call this morning from someone claiming that grandma's life insurance agent, so the will that the potential client sent to us this morning was actually signed like at the end of 23. But the will that was admitted earlier this year was signed at the end of 25. And I'm like, who the hell is this guy? Because like the people from before are nowhere to be found on this new version 2 years later. And I'm like, who the hell is Mario? And he was like, that's the life insurance agent for my grandmother. I'm like, the life insurance agent? Yeah, he supposedly came over to sell her new health insurance, Medicare Part B or some bullshit. Somehow he ended up in the will. I was like, this is crazy. Sometimes Miami's a crazy place, though. You've been here longer than I have, so Miami's a crazy place.
I had a case with a lady, and the daughter came to me, and she was supposedly close with her mother, but then she found out that the caretaker ended up doing a quitclaim deed, adding her name to the title to the property. And I'm like, it makes me wonder, how close were you that you allowed this caretaker to go to the hospital with an attorney to execute a deed? And I fought it with property appraisers, and it got changed, and it got changed back because they fought me tooth and nail on it. And they said, we can't get involved in this because it's a civil matter litigation, but we let it stand. And it went to court, and the woman got arrested and brought charges by attorneys. Yeah, and she finally got convicted, but it took a I don't do the litigation, extended litigation like that, but it took several years.
Yes,
to turn it. But again, it makes me wonder. I said, I know you say you were close to your mother, but how did you allow this to happen?
Yeah.
Deeds come in and the caretakers come in and slip it in there and get it.
And this is a great point because, I'm making fun of the caretakers here, but sometimes, especially when they're really not close to their kids or their kids live somewhere else, right? My grandmother's still alive. She turned 95 March 26th of this year. A pantera, as we say, she is, she's cranky and she's like, I don't understand why I'm still alive. I'm in my eye, like her vision, because she's been diabetic for like 40 years. So she, like, the vision is starting to go. But she lives in her house with my grandfather. And my great-grandmother died around that same age, was taking care of me when she was in her 70s as her, like, first grandchild, and they were perfectly in their right mind. Like, my grandmother today is absolutely in her right mind. So there's sometimes that I think, man, if you are estranged, and maybe it's not even estranged, you're just not that close with your mom anymore. And I don't know the situation of yours, this scenario, and you become very close with the lady that's taking care of you. And you become friends. And she's been taking care of you for 10 years and whatnot. To what extent, and this is always to be litigated, and what capacity is there, who knows, and what influence is being, put upon you, who knows. And all these things are extremely factual and extremely hard to prove one way or the other. That's why we end up settling most of these cases. Because if it's not blatant fraud, if it's not blatant, like sign here, Abuelita, and you don't even know what you're signing in the hospital, right? But there's an extended relationship with the person that's taking care of you or whatever it is. There's always this idea of, hey, if grandma still had capacity and really thought, the person I would really love to leave my apartment in Blue Lagoon to is this person that's been taking care of me forever.
Yeah, I'm sorry to interrupt.
You know?
I was just saying, I deal with a lot of clients too that they're widowed or they don't have children and they have this established relationship with a caretaker. That's the only person that's taking care of them.
Right.
You know? And I do what I do with them as a lot is ladybird beats. I do a lot of ladybird beats, which I like to do because, they reserve the rights to change it at any time.
Right.
And up to the moment of their death. And upon their death, they've set a beneficiary in this deed. And so in that type of circumstances, and I feel it out, make sure that there's no undue influence or anything like that. But if it is a relationship where they do take care, because they have nobody else to take care of you. And if this person is young and they can take care of you, why not?
A lot of money fixing those and trying to invalidate this or clawing back the property from the caretaker, even if it was a ladybird deed, it really can be very taxing. So I hope, caretaker has a few properties now, so she'd be able to pay for litigation.
Exactly. And I guess coming back to Tony Hsieh, if the will doesn't get admitted or he has no capacity, then it's going to be an intestate.
That's right. And mom and dad are alive and they're going to inherit everything. No more Harvard, no more Gates Foundation, no more Red Cross, and no more Mr. whatever his name is, Kiefer C, or any of these very weirdly named irrevocable trusts that nobody can find. None of that's going to happen either. What was also interesting, because you can see to the extent that the investigation has happened in the estate, this will, assumingly, because it's dated, was signed on whatever it was, March 13th of 2015, right? 10 years before. And
he was here.
And he was here. He was in Vegas. He was in Nevada. And they were able to piece together like his entire calendar, right? Like they were like, what, are you kidding me? I guess the Spheno went out to Microsoft and they got the Outlook and they even got Evernote. I still use Evernote. And they were able to get the notes that he wrote on that day of the meetings that he had. So that's where he was storing his notes. I'm sure AI is going to make Evernote useless pretty soon. But I actually used to store notes in Evernote a very, very long time ago. So I laughed when I read that. And they were able to kind of piece together even like he bought a car. He bought a DeLorean. So there was like a whole thing about that of the time of delivery and this. And like, where in all of this did he have time to round up these 4 witnesses and sign this will? Right? The evidence starts looking pretty bad.
There's like $100 million, $93 million, $100 million in creditors claim.
Yes. Imagine all those guys with like their name on a sticky note, right? Are like, what do you mean? I was promised this, or whatever. And that there's a lot of conversation about like the things that were promised or the contracts or whatever, or the projects that he started to invest in that had like a vesting schedule of money that needed to continue to be paid. And figuring all of that out is going to be a fun time. I call that the mayhem, chaos, and foolishness. Foolishness is what that is. So the estate is at the point where we had this 7-page handwritten will that was under the custody of Mr. Muhammad in Pakistan. Mr. Muhammad passed away while they were assumingly settling his estate and figuring out his stuff. Will discovered, somehow made its way to Connecticut, Pennsylvania, the Northeast area, and then somehow mailed to the court and mailed to the attorneys that are supposedly going to be personal representatives. The witnesses don't exist from what anybody, and certainly haven't come forward, from what anybody can gauge. The signature has been determined, at least by, of course, dad experts, a forgery. The will misspells Tony's middle name, which was also kind of interesting. because he has like a hyphenated, Asian middle name that's on his passport, and actually all of his previous documents where he signs his name, he does sign his hyphenated middle name, which I thought was interesting because my signature at this point is like too sweet.
You would think you would catch that if you're signing a will. You would catch that your middle name is misspelled, right?
Yes, like guys, there, there are ways to do fraud better. Like, I have to say, this could have been done slightly better. Like, this isn't even, one of those cases that you're like, oh, okay, like, no, this is allegedly not a good fraud. So, even if the will somehow gets in, it's already been, quote, I don't know if it's admitted. Here in Florida, like you submit the will, it gets admitted, and then everybody starts fighting about its validity. Here, I feel like it's kind of in this purgatory. It's kind of in limbo. So I don't know if it's officially by Nevada law been admitted. But let's say even if it never gets admitted, for sure, like we discussed, dad and brother will probably immediately say, I don't care what it says. I don't think my brother had the capacity to sign that. He was heavily under the influence of a lot of drugs, acting very, very weird, becoming more and more eccentric, going to crazy parties and doing crazy things and hanging out with 20-year-olds and doing all sorts of whatever. So, I don't know what the line is for eccentric billionaire and incapacity or some diminished capacity. I don't know how many of those calls you get. We have gotten so many calls over time of people going, my daughter, like the helicopter parent, like the daughter is now 20 and the daughter is having a great time and couch surfing on friends, whatever. And there's pictures on Instagram of, them doing certain drugs and at the club and whatever. And mom, it's usually mom, is calling going, I want a guardianship over my daughter, right? And to try to explain to mom that there's a difference between hashtag living your best life, kids. I don't know. These kids have all sorts of hashtags like versus true incapacity, right? What is the line between I'm 46 and I'm a billionaire and I will take all the damn drugs I want because I can versus I have diminished capacity. Like my old partner Jason used to say, we are not doctors. It is not my job to determine that at all. We're going to need testimony and we're going to need facts. And
It's also like when they come in for a power of attorney or something like that, and they have some type of dementia or something like that. Well, you can have dementia, but you can have a moment of clarity.
Absolutely.
We are not doctors. We cannot determine.
It is not my job.
We make a determination that they had capacity or they were clear in that moment.
That they understand.
And they can execute the document. And that's sufficient, but we're not doctors that, make that determination, that call.
Yeah.
But, we have to use common sense and make sure. And sometimes we may even videotape the thing if it's questionable, the actual signing of the documents or something like that. But yeah, again, we're not doctors,
No.
You can live your best life.
Yes. Hashtag living your best life, kids. I don't know.
And still have capacity.
Yeah. Yeah. So to what extent after someone has passed away, it's hard enough to determine capacity, in life, in guardianship proceedings. So to what extent you're going to get the 20-year-olds in Park City that are doing the drugs with him to say what his mental state was or not, or the friends from 2015 when this will was allegedly signed before it was shipped to Pakistan. Like this is all, oh my God, a whole nother thing. And then forget all of this. I mean, the biggest thing, the only thing I thought we were going to be talking about today, truly, before I saw that New York Times article in a couple months ago, was that I thought we were going to talk about very interesting kind of forensic accounting type stuff and how we hunt down assets and how you get to the bank account and see how money moves. And it's a fascinating type thing to do that. You almost become like high-end divorce lawyers have people that do this too, right? When you're trying to kind of fleece the estate, the marital estate, allegedly. And so that's always super interesting, but piecing together the Post-it notes and the erratic things and notebooks. And this is the Aretha Franklin with all her stupid notebooks. And I'm like, I can't believe this. If a woman knows she's sick, she knows she's going to die, and all of a sudden we find multiple notebooks of handwritten notes that are all going to supposedly a will. Come on, guys. Come on. This is...
Well, as you know, too, it's like, we have clients, and especially living in Miami, Brazilians also, they don't want to do a will because they think they're superstitious. Yeah, the moment I do it, I'm going to die. So it's like, all right, well, but, so here's Aretha Franklin writing her nose, which is like, it's getting formalized.
With an old will in a cabinet.
Who knows what was going through her head.
Like, it was, I mean, that's one of the more bizarre ones because you do know certain things, you do have a certain level of sophistication, you have a certain level of money, and you still don't take the time to do it correctly.
Right? Or the other thing where they also don't want to spend days like, I don't want to go to an attorney because I don't want to spend the money. And it's like, that's ridiculous. I was like, it's going to cost you so much more by not taking care of business. It's really not, we've been practicing for a long time. We charge well for our job, but it's a lot less than what your children have to go through. And
it's going to be a lot less.
A lot less. So, snap out of it.
We definitely make more money on the probate or on the probate litigation side than we will make on the planning side, guys. Yeah, for sure. For sure. So, I mean, any last words about this estate, George? I know we've talked about a lot, and it's an ongoing saga. I mean, this is to be continued. I don't know when there'll finally be some type of final hearing on the validity of this will, maybe after the ink gets dated or whatever. And I'm sure there'll be more news about it. And we could do round two.
I would love to. This is my first podcast, and this has been a pleasure.
Thank you so much for coming, Drift.
I've enjoyed myself, so I hope you did too, and I have enjoyed myself, and I hope you did too. So there you go.
And all of George's information will be everywhere in YouTube. We'll have it in the bottom, all over. We'll tag you on social media. Thank you so much, George. And I hope all of you got something out of this episode. Join us next time for another episode of Having Fun with Death and Taxes, because whether you're a celebrity or not, whether you have $1 billion or not, you should plan ahead to protect yourself, your family, and your assets. Till next time.